So thank you for joining, everybody. Welcome to our final day for the FLVS 2020. Today we have a very special guest with us again. Yesterday we already had a panel, and I want to welcome Frans to the stage. This is a distinguished professor in exploring and addressing questions of the outer space resources, an author of many books, and a member of many space organizations, indeed. So Frans, would you like to introduce yourself briefly?
Thank you. Yeah, well, I'm actually, as I said also yesterday, I'm wearing two hats, an academic hat as a professor of space law at the University of Nebraska-Lincoln. And by the way, I'm also temporarily on an associate research professorship with the University of Lazarski in Warsaw. And then my non-academic hat, my consultancy hat, is my own company, Black Holes, which is residing in the Netherlands, which works with any client interested in learning more about space law or requiring to learn more about space law and space policy. I'll keep it at that. If people are interested, obviously there are several websites which they can visit, which give more detail.
I do have to say that this is an author of a Bible for space. So space law, the handbook on space law, that has been an incredible resource for starting to learn everything about how the law was created and how we proceed and where we are today and what the future possibly awaits us. So I invite you to share the presentation with us. You can share the screen and let's dive into another black hole of ours.
Great. Thank you very much. So I will indeed share my screen, which is what I'm doing right now. If I'm not mistaken, can I get, yeah, I get a thumbs up. Go. Yeah, I took the liberty of changing the title a little bit. The main part is, of course, as you can see, who owns the moon? But the next question, even though we are going to go a little bit into space law, is, of course, why that question is important in the first place. Because you may not perhaps realize this, but whenever I tell at a reception or another festivity that I'm earning my money with teaching and educating and researching and advising on space law, the first reaction is a big question mark, or people start laughing. And then the second question is actually, who owns the moon? Again, meant as a kind of joke, but part of what I'm going to talk about is that this is really an interesting and important issue. And there is at least one man who thinks he claims the moon. And I don't make this up. I'm going to show you a short video clip from a Dutch TV program a few years ago. Don't worry, only the subtitles are in Dutch. The information is in English.
Good afternoon, William Galactic Government Headquarters. May I help you? Yeah, we actually have been selling property on the moon since 1980. Properties that we're currently offering for sale are the moon of Earth, Mars, Venus, Io, and Mercury. We've sold just under 600 million acres on the moon so far, and that's growing by about 200 properties per day. All of the red areas here are areas that we've already sold. This staff would ask me, we're out of properties, we need to select another area, we just sold that one out. Where do you want to do it? And so I just cover my eyes and go like this. There's just under 10 billion acres on the moon. And everything you have sold belongs to you. Yes. During 1999, a person by the name of Pop emailed me and told me that he had claimed ownership to the sun and that he was charging me $30 million a year for the energy put out for all the planetary bodies that I own. I waited a couple of days and wrote back to him and said, we've decided we don't want your energy. Please turn it off.
So obviously that's a nice joke, and it would not be bad if it would have remained as a joke. Oops, I'm sorry, I'm now doing something here. This guy is Dennis Hope, by the way, the man you saw in the picture, and he thinks he is entitled to sell the moon because he claims he owns it. And his arguments, for what they are worth, are that he registered his ownership back in 1980, as you saw in the clip, at a local office in California, and the registration of his claim to ownership was accepted. I'm going to come back briefly to that. He also wrote, by the way, or that's at least what he claimed, to the two leaders of the two most important countries at the time, the only countries who had actually done something specifically with regard to the moon, the United States and the Soviet Union, to their two main persons and the UN Secretary General as kind of a representative of the rest of mankind, telling them, I am going to sell parts of the moon. Do you have any problem with that? And he didn't get any answer back saying, no, you're not supposed to do that, which gave him the impression that he was entitled to do that. Now, of course, this may sound all like a big joke, right? If no one in the right frame of mind would buy something like that and really expect to own part of the moon, that's what you think at least. And for a long time, it remained like a funny story, if you will. But the guy has become a multimillionaire, and if you see in the clip, he has already managed to branch out to other planets. He also managed to branch out to other countries with his company, which is called Lunar Embassy. And things are getting serious because we should realize that as a consequence of this event, a lot of confusion reigns in terms of how the moon should be treated now that we are serious in not only going back there, but also probably going to mine there and even live there for a long period of time. So what you saw, as I said, is a number of clients which he managed to sell parts of his so-called lunar property to. And the main question is then, can such a client assume that they really own that? And when you are just a handful of persons who have bought a piece, you probably realize this is more like a joke. But if there are millions of people doing that, probably some of them will actually think that they really owned part of the moon. So in the late 1980s, when I was working in the Netherlands still at Leiden University, there was a German guy called Martin Jurgens who realized that he had up on his in his attic an old document. A forefather of him back in the days of King Frederick the Great of Prussia had done a great service to the king, and the king, in his majestic generosity, had given him the moon in ownership. And now he realized that this American guy was trying to sell parts of his moon and make money of that. So he tried to actually get the German government to take diplomatic action against the United States for making sure that that was not about to happen. And of course, many people did not take it seriously, but I remember there was a time that almost every other week I got a phone call or an email of people asking me, is this real? Should I buy this? Does it belong to Germany or does it belong to the United States? I was always tempted to say, well, you can buy the same parts, the moon, for half the price of me, but obviously as a law professor, you can't really do that. And this was not all. I remember that somewhere in 1990, I was sitting next to the NASA legal advisor at a dinner at a conference, and I was explaining him all this as a nice story, but also with the undertone, wait a minute, there are some problems here. And maybe the United States should do something about making clear that Dennis Hope cannot be seen as a valid owner of parts of the moon. And that's probably something for the US government to make clear to the rest of the world. At that point in time, the NASA legal counsel sort of laughed a little bit and said, well, you can't take that seriously, right? Well, lo and behold, a few years later, there was an American guy called Greg Nemitz who claimed property rights over an asteroid called Eros 433, on which NASA had just landed a rover, and he sent NASA a claim for parking fees. Now, the money was not big. It was just a couple of dozens of dollars that he wanted to claim. But NASA had to take great care for a number of years and pay a lot of attorney hours before they were certain that no court would ever grant this right to Greg Nemitz. In the end, they were able to get rid of this nuisance, but it tells you that there are these unforeseen consequences of something which may start out as a joke. Now, in Yemen, there were some people who claimed the same thing with regard to Mars. I haven't heard anything about that, so that claim must have died a silent death. But there was also an Italian competitor who thought, well, what Dennis Hope can do, I can do just as easily. And an Italian lady got all upset because she bought a plot from Celestis, which she then found out was sold by Hope to someone else. So again, you may think this is one big joke, but as we will see, it raises some serious issues. And that, of course, is where the law comes in. Now, Anja kindly referred to my handbook. That's a full 1,000 pages on all of what one could include in the concept of space law. I will just limit myself to a very minute crash course on space law and tell you that, of course, space law started to become an issue in 1957 with the launch of Sputnik, the first human-made artifact which went into outer space, which gave rise to the first discussions in the United Nations, led obviously by the Soviet Union and the United States, who were engaged in a Cold War as political adversaries and the two main countries acting in space, on what the law should be applicable to such space operations. And that's basically where space law started, if you look at the heart of the matter. These discussions gave rise within, I would say, quite a quick time period, only 10 years, which is not long in the international community for a treaty to arise, on a treaty which is called, for short, it has a much longer name, but for short it's called the Outer Space Treaty. That's the most important, the all-encompassing treaty which regulates the legal behavior of states in outer space. So every course on space law, every primer on space law should start with the Outer Space Treaty. I'm going to obviously run you through some of the most important principles, also with a view to these questions that later came up: who owns the moon? And see to what extent the treaty may give something of an answer to that. Well, the most important part of the Outer Space Treaty, and we should not forget that not only the United States and the Soviet Union, but also China and France and Brazil and the UK and Germany and all important spacefaring nations adhere to this. So this is really the basic law for outer space. The Outer Space Treaty has probably as its most important article, Article 2. And I usually am not fond of quoting complete articles on slides and in presentations because that tends to get a little bit boring. But this is such an important article that I couldn't leave you without the full text. So it reads: outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. Now, the next question that any lawyer should ask, of course, is, well, what does that exactly mean? Those terms are not, we are not so familiar with them that every lawyer automatically understands what they mean. Well, probably you know from the days of your history lessons at school that in particular Western European countries were prone to putting their flags all over the world, the rest of the world, I should say, and claim those countries for the motherland as colonies. And there was a big worry in many circles that what those countries did back in the 15th and 16th and 17th centuries would also expand into outer space and would also generate a land grab there, which would obviously be not very conducive to the peace. So what Article 2 starts out by doing is basically saying, that is all history now also for the moon and other celestial bodies. We cannot apply that. You cannot plant your flag there and call a part of outer space your own. Now, of course, many of you will have seen this iconic picture of the American astronauts in 1969 and the following years planting a few flags on the moon. And as I already said yesterday, that did not mean that the moon was claimed to be US territory. The United States and NASA took great care to make sure that nobody took this the wrong way. The famous words of Neil Armstrong spoke of a small step for a man, a giant leap for mankind, not just the United States. And I should apologize, you can clearly see that this is a phrase going back to a couple of decades when women were hardly visible in outer space, because obviously it should mean a small step for a human and a great giant leap for humankind. But this was the historic version of it. But what is important here is that it was an important leap, not just for the United States, but indeed for all mankind. And again, the United States, NASA took great care to make sure that nobody took this the wrong way. They shared everything they brought back from the moon. They shared these moon rocks with scientists from all over the world, including the Soviet Union, which, after all, was still their kind of enemy in the Cold War. Now, going back to Dennis Hope, of course, somebody told him about Article 2 of the Outer Space Treaty and that he was not supposed to own it. And he was thinking he was a little bit smart, because he said, well, yes, I know that provision. It speaks about the prohibition of national appropriation, but that means that it only applies to states, like the whole of the Outer Space Treaty only applies to states. So there is a famous concept in legal thinking, which is called a contrario reasoning. If something is mentioned specifically and something else is not mentioned specifically, then you can argue that the latter thing, by contrast, is allowed. So the fact that there was no reference in Article 2 to private persons and private property, in his view, meant that private persons can own the moon. Well, if you think twice, that is a fallacy too, because what this supposes is that there is a regime which provides a private person with ownership rights. If we go back to Dennis Hope, the way he got ownership rights over the moon was using a US law going back to the days of the Wild West, which was called the Homestead Act, which allowed a person to claim a piece of wild land, uninhabited, by basically putting a fence around it and posting a claim somewhere in a local office. And if within 3 months or 6 months or a year, nobody came up with a better claim, it was formally registered as his property. That's exactly what Dennis Hope did with the moon. The point here is, however, that the Homestead Act, the act which gives private owners, private persons, the right to own land, to own real estate in the United States, is a US act which only applies to the United States. And because of Article 2, the moon is not part of the United States. So whatever the Homestead Act does may well and good apply within the United States, but it may not apply to outer space or a celestial body. So by that token, his ownership is basically meaningless, or you can even call it a fraud. We will come to that shortly. Before we do that, I'm going to run you through a few more articles of the Outer Space Treaty, which are of importance here. Article 1 requires that the exploration and use of outer space are for the benefit of all mankind and should not be limited in terms of access and benefits to a few states only. A very important article talks about state responsibility, and for those of you who were with us yesterday at the panel, this may by now sound familiar already. States are responsible for private space activities, and these private space activities require authorization and continuing supervision, which is why so many states these days have already established a national space law in order to authorize and supervise those activities, because the states are going to be held responsible for it. And that number is growing, by the way. And also this article makes clear why, on the one hand, I suggested to NASA and its legal counsel, well, maybe the US government should do something about it, because it's the United States which should make sure that its citizens do not behave in violation, for example, of Article 2 of the Outer Space Treaty, this non-appropriation prohibition. And it also makes clear that the fact that Article 2 only refers to states does also include any private citizens of the state. So the fact that national appropriation basically is an obligation for states to comply with, or a prohibition for states to comply with, extends to any of their private citizens. So in the end, Dennis Hope's arguments fall flat, but he has nevertheless succeeded in becoming a multimillionaire. Let's leave that aside. Last slide on the articles on the Outer Space Treaty so far. Another important article is Article 7, which talks about liability for damage, which again is resting upon the state. A private actor in outer space, whether it's on the moon or in an Earth orbit, if he or she causes damage, it's still the state, the launching state, which has to pay for that damage, at least on the international level. And Article 9 finally requires states to behave like decent citizens. They should consult in case of the likelihood or the possibility that their activities in outer space cause harmful interference, and that then hopefully leads to a peaceful solution and a compromise which allows all states to benefit from outer space. Now, what about the moon? You maybe recall one or two articles which already include the moon and other celestial bodies in outer space as a whole, but there is only one article which speaks about the moon specifically. And we should realize that already from 1959 onwards, so 8 years before the Outer Space Treaty, the first unmanned landings took place on the moon by Soviet robotic probes. So the discussion on what the legal regime was specifically for the moon started already very quickly in those UN fora, which I mentioned before. Now, the only article which sets the moon apart, and other celestial bodies, I should say, is the Outer Space Treaty, Article 4, which says that the moon and other celestial bodies can only be used exclusively for peaceful purposes. That really doesn't tell us anything more about ownership, although when it comes to ownership as such, Article 2, I would say, is clear enough. It wasn't clear enough for Dennis Hope and his clients, perhaps, but for any lawyer worth his salary, it is clear that you cannot own the moon. And for many years, that was enough. But then what happened was that, of course, in 1969, 1972, the first moon landings, and so far the only moon landings, took place, which generated a lot of enthusiasm about the moon. There were a lot of moonstones brought back. At that time, they were really for scientific purposes. It was just a handful of kilos. It wasn't a huge amount of rocks. And it was selected specifically to find clues to the age of the moon and whether the moon had been part of Earth billions of years ago and that kind of geological questions. So there was no commercial interest involved, but it seemed that commercial exploitation was around the corner. There was a lot of interest in the day. I'm going to come back to that in a second, in something called helium-3. And of course, now we speak about water and other minerals as well. And this exploitation, this idea in the early 70s that we could not only land on the moon, but actually start exploiting its mineral resources, again, raised the issue of, well, what is the exact legal regime which applies to that exploitation? We know that you cannot possess the moon, but what does that mean about the right to exploit it or to dig there, to mine there, and to make money with that? Now, again, to show you that I'm not just all making this up, I have another clip from the same story, same Dutch TV program.
If we had gold bricks stacked up on the surface of the moon, we couldn't afford to bring them back. This material at several $1 billion a ton is what makes it all worthwhile. There is nothing that we know of in the solar system that is worthwhile going out to bring back to the Earth other than helium-3.
Helium-3 could become the new fuel of the 21st century, a source of fusion power that could provide an almost inexhaustible supply of clean, pollution-free energy.
It would, over the long haul, replace, for electrical power production, not only fossil fuels, but would replace nuclear power as we now understand it, fission power.
If these men are right, whoever controls the moon might just control the world's energy supplies for hundreds of years to come.
Now, the second of the two speakers that you saw was this guy, Harrison Schmitt, who actually was the last man to land on the moon back in 1972. He was also the only geologist. All the others were fighter pilots or test pilots, but Harrison Schmitt was the only proper scientist, although he was then also trained as a pilot and as an astronaut. He was the only geologist who landed on the moon, and he came back in 1972 convinced that helium-3 was the way for the future. Now, that turned out not to be the case. I happened to sit at a dinner next to him 2.5 decades later, and he was very disappointed because he said, well, I made my pitch to many important people, and of course they are all full of respect because astronauts who walked on the moon are basically public heroes, certainly in the United States, but in many other countries as well. So they all listen to me. But when I go out the door, you already almost hear them nodding. This is not going to work. This is not going to be it. And other scientists are of the same opinion. So to put a clear perspective on this, so far, this has never been picked up seriously. And as a consequence, it hasn't worked out so far. But then things started to change. And I'm making a leap in time now to the early 2010s. There were two companies. One is what you see here on the slide called Planetary Resources, which specifically was going to expand the natural resource base of the Earth by developing space mining technologies. They were going for asteroids. Small sidestep here. Legally speaking, asteroids and all other celestial bodies are in the same basket as the moon. So this Article 2 applies to them, and all the other parts of the Outer Space Treaty apply to asteroids, just like they apply to the moon. 5 years later, they did launch their first test satellite, and they were backed by a couple of people, as you can see in the slide, with pretty good names, and not only pretty good names, but also pretty good money. We're talking about many millions behind this enterprise. Now, currently it is going through a restructuring process, so it may well be that that the whole plans are being suspended for the time being. I see this process as something like the Echternach procession, 2 steps forward, 1 step back. This is the 1 step back, but maybe 2 years from now or 5 years from now, somebody will pick this up again and we will move forward again. But in 2010 and the following years, Planetary Resources was pretty serious, and they were actually not the only company. There was another company called Deep Space Industries, which essentially, you find a little bit different terminology on their websites, but it was essentially trying to do the same. And it was founded by someone who has made a name in space as being a very active space entrepreneur, activist. Some even would call him dreamer. But he always managed to get money to fund some of his projects. Also, Deep Space Industries is a little bit in trouble these days. So they're in this 1 step back mode. But who knows what's going to happen. But in the mid-2010s, they were starting to get very serious. How serious? I'm going to show you 2 more clips of a different Dutch TV show, but again, only the subtitles are in Dutch, to tell you this story. The first is the following.
What will tomorrow look like? Our world is at its limits, and yet we all want more. And why not? Why shouldn't the future be brighter than today? But where will it come from? Simple. Our tiny planet sits in a vast sea of resources, including millions of asteroids bathed in the sun's free energy 24 hours a day. The same rocks that could fall from our skies also contain everything we could ever need, both out there and down here. It's time someone seized the opportunity.
Now, I should immediately add that this clip was part of DSI's advertisement back in the day. So it's, of course, painting a rather rosy picture. And as I said before, we're currently 1 step back. So who knows what's coming of this. But I'm going to show you another clip, which happens to show both the legal advisor of Planetary Resources and Deep Space. And you'll hear the advisor of Planetary Resources say, amongst other, that already at that point, the company was making some money with activities which were only supposed to lead up to deep space activities, to the actual space mining. So it's certainly not something which is off the books right now, only because there are some economic problems.
So there's 3 things we're looking for on asteroids. 2 of them we plan on leaving in space, and one group we'll take back. The first thing we're looking for is water. Water seems to make no sense to most people when you think about it. Why would you bring water back to Earth, and that's why we're not bringing water back. But water in space is incredibly valuable. It serves a variety of functions in space. If you're an astronaut, you sure would love something to drink. It's also good for growing food in space. And if I take water and I split water in half, I've got liquid hydrogen and liquid oxygen. I've got rocket fuel. The other thing that are on asteroids are metals. So things like nickel and iron. Again, something we wouldn't bring back to Earth because we've got iron and steel and things like that here. But if you want to build something in space, the best thing to do is to use what you've got there. And so we'll use those resources that we find in space to build new structures for space stations or habitats or whatever else. The third one is the one that people seem to like the most, and that's platinum. There's a tremendous amount of platinum locked up in asteroids, some platinum group metals. And that's what we would bring back to Earth, because platinum group metals are extraordinarily scarce on Earth. We're not finding any more. We're closing down mines here on Earth because we're running out of platinum to mine. And that's what we would bring back to Earth, is these platinum group metals.
Asteroids have the raw materials that you need to develop two things: a space infrastructure, the actual infrastructures in space, structures such as free-floating structures, such as gas stations in space. When humans continue to explore space, as they move forward, they're going to need to refuel. They're going to need water. They're going to need structures that need to be developed in space, because it's cheaper to develop structures in space than it is to lift them off the ground. It's something like $11,000 per pound of mass to lift from Earth. So that's very expensive. So that's not economically sustainable to develop a space infrastructure in the space economy.
We have a saying in the company that the most valuable resource in space is people. Eventually we will get to the point where there are people in space, and that those people in space are going to need resources to survive and live. So we have a business plan that makes us a profitable company right now. But of course, our long-term dream, just like you've heard from Elon Musk at SpaceX, where Elon wants to create a colony on Mars, our plan is, well, let's provide the infrastructure and resources for those colonies and people to do exploration.
So that, of course, brings us then back to the question, what about the law for all these plans? And these two projects, I can say, really brought that question back on the table, which had been largely theoretical ever since the Outer Space Treaty and even the first moon landings. So going back to the Outer Space Treaty, we should realize that it did not consider, simply because it was on nobody's radar screen at the time, it did not seriously consider anything like commercial exploitation of celestial bodies. That simply was not expected to happen anytime soon. Now, because of the idea in the 70s that maybe we want to go back to the moon and or stay on the moon and do some harvesting there by states, I should say, there was at least a first attempt. In 1979, there was an agreement on the text of a further treaty, which is called for short the Moon Agreement, which was mainly, I dare say, intending to address this kind of commercial exploitation of the moon, which, as I said, at the time seemed to be about to be feasible, and then things took a different route, and it never worked out, but it was considered necessary to at least prepare for the occasion. Now, it should be pointed out that on the one hand, the original text, as it was finalized in 1979, was developed in agreement between major spacefaring nations, including the United States, and I should add at the time the Soviet Union as well, of course. But then something happened, to which I will come in a minute. The result was that it was never ratified by those states. And of course, everyone who knows their public international law knows that if you don't ratify a treaty as a state, you are not bound by whatever it says. The current status of the Moon Agreement is that 18 states have ratified it. But I think it's fair to say that none of them are really major spacefaring nations. So for all the major countries, not just the United States, but also Russia and China and UK and France and Germany and Brazil and India and Indonesia and Nigeria, they are all not party to whatever the Moon Agreement says. So in legal terms, in terms of what does it provide for a legal regime applicable to everyone, it has very limited scope. Nevertheless, it's interesting to take a brief look at it. And I'm sorry, this should of course read the 1979 Moon Agreement instead of the 1969 one, because it was 79. It did establish the moon and its natural resources as the common heritage of mankind, which at the time was a new phrase which had only been heard in the context of the law of the sea, where at about the same time, 1974 to 1982, a major convention was also negotiated, which included discussion of the deep seabed as the common heritage of mankind. And it didn't only define those resources as the common heritage of mankind, which already suggests that there is a need for a special legal regime to allow exploitation thereof. It actually said we need an international regime to handle that. But the Moon Agreement didn't provide any details. So what happened was that after 1979, when the text was ready for signature, the main spacefaring nations started realizing that when in the law of the sea context for the deep seabed mining, this regime, this concept of the common heritage of mankind was elaborated in quite some detail, in contrast to the Moon Agreement, which, as I said, was very superficial on this. But in the law of the sea, it was developed in quite some detail. And that regime included an international licensing system. Operators could only be entitled to mine the deep seabed if they could get an international license. They had to share the benefits and they had to share the technology. And then the major states said, well, then we're out of the game. We don't like that approach at all. And they were out of the game, not only in the terms of the Maritime Convention, but they also said if the common heritage of mankind principle is going to mean exactly that, also in the context of the Moon Agreement, we don't want to be part of that. So that's why the Moon Agreement remained unsuccessful. Now, it does provide, nevertheless, for a few interesting provisions. Also, the Moon Agreement talks about non-appropriation, but it talks about non-appropriation of natural resources in place, which any good lawyer will realize, at least strongly suggests that once you take the natural resources out of that place, out of the moon soil, you can own them and do with them what you want. Which is what mining is, of course, all about. It allowed also, the Moon Agreement also allowed for the possibility to develop specific legal norms to enter into force to separate, for example, between the moon and asteroids. And that is an important issue. It hasn't happened before, but in theory, if the Moon Agreement would ever make it into mainstream international law, you could think about distinguishing between celestial bodies which are big enough to be really called a celestial body, or something which is merely a natural resource because it's too small to be a real body. What I mean is, look at the moon, a major celestial body. Here you find some of the figures about its size. These are huge numbers. If you talk about asteroids, which planetary resources and deep space we're talking about, one of the most famous ones is Itokawa. Look at the dimensions. That's small. That's just a giant rock, nothing more. Do you really need to call that a celestial body on which you can land, or is it just a piece of natural resource which you can grab? So even the Moon Agreement leaves some interesting pointers as to what the regime might be for harvesting celestial resources. But basically, we have to go back to Article 2. And Article 2, as I said before, only provides for non-appropriation of the territory, but it doesn't indicate what that means for space mining. And here is where the opinions started to diverge when roughly 5, 6, 7 years ago, these discussions started to become serious. On the one hand, you had the argument that outer space belongs to all of mankind. It's a global commons. Nobody can own any part of it. So logically, all the resources therein should then also belong to all of mankind. Which meant that you indeed need a kind of international regime, which doesn't necessarily include an international license, but might well do, but at least an international regime to regulate commercial exploitation. And there were some examples around. One of the most famous ones were satellite communications, where if you want to run a satellite system, you need the International Telecommunication Union to sign off on your use of frequencies and orbital slots. It doesn't require an international license. The licensing is still a national matter, but it has to fit in this whole international system. Or do we go back to the deep seabed mining on the high seas, after all, which was originally this heavy regime, but this was then changed in 1994 to become much more palatable to the major industrial countries. There was no more mandatory sharing of benefits or transfer of technology. There is an international licensing regime, but the process is now dominated to such an extent by the big industrial states that commercial companies usually can get a license if they want. Only the United States did still not ratify. All the other Western countries found this enough of a compromise to be workable. But even in the United States, a company like Lockheed Martin chose to establish a subsidiary in the United Kingdom to get an international license. And you will shortly see why they did that and choose to go the different route rather than the easy one of remaining just in the United States. But before that, we have to understand that this whole Article 2 provision also allows for another interpretation, namely to say that this is indeed a global commons, which essentially means that everyone is entitled to use the resources for their own benefit. In first instance, every state, but since states can authorize and supervise national entities, if they are properly authorized and supervised, also private operators in principle can entitled to use those resources, as long as they comply with international law and they get a national license. That is okay and they're good to go. Now this looks a little bit like fishing on the high sea, right? The high sea are a global commons. Nobody can square off 100 square miles on the high seas and says that's mine, and I'm, as a state, I'm the only one who is entitled to tell who can take fish there. Everyone can do that as long as they comply with international law on overfishing, prohibition on whaling, and prohibition on pollution and things like that. Once they have the fish in the net, it's theirs and they can sell it and make money with it. But there was still a lot of unclarity. So when in the international level, you don't have clear guidance, you have to do something at the national level. And logically, the first state to do something nationally was the United States. We spoke about it briefly yesterday. There was in 2015 an act which in one title addressed this specific issue of space resource exploration and utilization. It's a very short title. It just contains 3 articles and they basically provide 3 things. First of all, it recognizes the property rights of US citizens or companies on a first come or first serve basis after they've been taken out of the soil, so there's no reservation of mining spots, and then only as for disputes under US jurisdiction. If a German and a French company would go to the moon or an asteroid and do these things and have a fight over who owns that resource or that asteroid, it's not for the US to decide. It will be probably a French or a German court or maybe European court. But this is where the buck stops. Now, in addition, in order to comply with Article 6 of the Outer Space Treaty, the Act, the Title 4, requires for the development of an authorization and supervision regime that is currently going on in the United States. And finally, the most interesting clause really is that it calls upon the US President to promote the interests of the US industry in a global context, which essentially means that the US authorities, the US government, should convince the rest of the world that their approach of unilateral licensing in compliance with international law is sufficient for legitimate exploitation. And it is important to realize why that is, why the US is so interested in some form of an international regime. Because think about what happens. So we saw the possibility of bringing stuff back to Earth. If the companies bring this stuff back to Earth in the United States, they are okay, because the United States, by way of the 2015 Act, has recognized their rights to make money with it, to sell it, etc., whatever they want. But if they bring it back to any other place, it depends on whether that other country accepts that mining the moon on a commercial basis under a US license is a valid thing. If another country considers this to be something like blood diamonds, illegal contraband, they cannot sell it there, which means that it limits their market access. So that is why the United States wants to convince the rest of the world that this is a good thing to go, because that means that the rest of the world is now open as a marketplace as well. And that's also precisely why Lockheed Martin chose to get an international license through its UK subsidiary, because in that way, nobody could tell Lockheed Martin that whatever they took from the ocean floor would be illegal contraband, would be something like blood diamonds, and could be seized and forfeited. Now, of course, this also, the same problem applies if you land it in the United States and then try to sell it to anything else. And then there is, for lawyers, there's an interesting, so far theoretical additional catch. Under the World Trade Organization, or more properly the GATT, the General Agreement on Terrorism Trade, there is a rule which says that if products enjoy benefits from free trade regime, like products do as well. If platinum under the GATT benefits from free trade, then platinum from outer space is certainly a like product, and that might allow other states, or that might allow the United States to argue, well, this is legal. You cannot say that this is similar to blood diamonds. Whether other states accept that, however, is another matter. Now, as we saw in the clip, these companies were not only interested in bringing back the stuff down to Earth, they were also thinking of using it in outer space, either on a celestial body or on a floating space station. Well, basically, you have the same construction, right? If the space station on the moon or if the floating space station is a US space station, no problem, you're good to go. However, in any other case, and by the way, this is the Antwerp flag of the city of Antwerp, and I just choose it because I found it a fun flag, which represents a lot of flags. But any other flag, you have to question yourself, if the space station belongs to that other country, does that other country accept my resources, or does it seize them because it considers them contraband? Now, beyond the and then of course there's the question, does the GATT apply in outer space as well? I won't go into the details, but you can see there's a lot of interesting food for thought already here. Now, this gave rise to international discussions. Some countries sided with the United States. The earliest one actually was Luxembourg, who in 2017, so 2 years after the United States, proclaimed a similar law. It roughly states the same things. It allows ownership over extracted resources. It provides for a system of mission authorization to comply with Article 6 of the Outer Space Treaty, authorization and continuing supervision. And it includes full liability for damage based now or delegated now to the operator. Another country which sided early on with the United States was the United Arab Emirates, which a few years later included in its law, which was a general space law addressing the whole of the space sector, also the possibility to get an authorization for, well, you can read it here, for anything you want to do with regard to space resources. And the conditions have to be further determined, but it's clear that by that token, the United Arab Emirates consider mining in space basically a legal issue as long as it's conducted under a license, under an authorization, and in compliance with other international law. Now, not everyone was very happy with the US initiatives, as you can imagine. On the other side of the fence, you saw most strongly, initially for sure, Russia protesting. And these were some of the arguments that they put forward. They said that this was disrespectful for international law because it was the US taking a unilateral stance. The problem with that argument, I think, is that there is no international law which prohibits it. There's no international law which specifically allows it, but there's also no international law which prohibits it. So you're a little bit in between. It suggests that the US interpretation is a new interpretation of the non-appropriation of outer space, but the truth is that there was no old interpretation which was valid and applicable to space mining. There was a kind of a facetious argument that the United States until 1979 was in complete agreement with the text of the Moon Agreement, but then suddenly moved away. It is a facetious argument because the Russians did exactly the same thing. The Soviet Union and the Russians later on never ratified the Moon Agreement themselves. So how can they claim that the United States is disregarding those discussions? Then there is a political statement, which I won't go into further detail, that almost sounds like Cold War rhetoric. And then there is this effort to claim that the freedom of use of outer space is not law, but is a theory of some experts, which we don't need to take too seriously. Well, if you look in Article 1 of the Outer Space Treaty, it simply clarifies that the outer space is free for the use and exploration by all countries. So how can you say that this is just a mere theory? So this was more of a political game for the Russians than it was a legally game. Another country which was very much opposed to what they were doing was Brazil, and Brazil had considerably sounder legal arguments. They said, well, this is inconsistent with international law, at least the principles, maybe not the hard letter of the law, but the principles of the UN Space Treaty suggest that this is open to everyone, which is an argument that you can certainly make. In the end, I don't agree with it, but you can certainly make that argument. It's a reasonable argument. The second one is even stronger. Obviously, multilateral interests should take precedent over unilateral ones. That is clear. Outer space is for all mankind, humankind, I apologize. So you should have a multilateral regime. But the point was that the only effort to draft a multilateral regime, which was the Moon Agreement, had failed horribly. So there was nothing like a common ground at that point in time to build a mutually acceptable international agreement on. And then the last point is in the same line. Domestic legislation is a poor substitute for a multilateral instrument. And actually, even though they won't say that, the Americans will agree with you, because that's exactly why they're trying to get the rest of the world to agree to the same principle and to an international regime, a lightweight international regime, which allows national licensing. Now, going a little bit more deeper, you might wonder why Luxembourg is worth mentioning at all. Luxembourg is a country with, I believe, close to 400,000 people, so it's not a huge market. Can you really sell much more platinum to Luxembourg now that Luxembourg has accepted that? Well, Luxembourg is, of course, part of the European Union, and the European Union, in the treaty, the main treaty on the European Union, has a clause which says that products of third countries in free circulation benefit from the free trade regime. It's kind of similar to what the GATT applies, although it's a little bit stronger. So this means that once platinum has legally been brought into Luxembourg because Luxembourg is accepting the private ownership right of the mining companies, then all the other European Union countries have to accept it as well. So suddenly, instead of a market of 400,000, you talk about a market of 450 million. So the Luxembourg very smartly presented themselves as the gateway to Europe. That's why it is very interesting. Now, this leads to another bit of a problem, because there are 3 EU member countries, Belgium, the Netherlands, and Austria, who are parties to the Moon Agreement, who are now basically, if this ever comes to reality in the next decades or so, are caught between a hard place and a rock. On the one hand, they have to honor the EU law, which means that they have to recognize the legality of platinum brought into Luxembourg. But on the other hand, they are, under the Moon Agreement, required to see this as probably a violation of the common heritage of mankind, as something illegal. So how that will play out in the future, everybody can think about themselves. I want to mention, at least in terms of the flags, one other country. Oh yeah, this point was just to make clear what I said right now. And the Moon Agreement suggested that you cannot, at least suggested, doesn't say it exactly, but at least strongly suggests that you cannot allow unilateral ownership over resources, and you should share them with everyone around. Now, a final country of importance here is Australia. Australia also is party to the Moon Agreement, but at the same time, Australia was very interested in serving as a potential landing site for mining operators. After their mining operations, they could use Australia, which, as you may know, consists for about 80% of desert. So if you are not too precise in your landing, it still is not a big issue. You still are unlikely to cause a lot of damage. So they were interested in being part of this game. But since they were also party to the Moon Agreement, they would be faced with the question, are we not supposed then to seize whatever these mining companies bring back into Australia? Now I will wind up with the last developments, and then we still have a few minutes for questions if there are such. The latest developments is that we do see increasingly countries signing up with Luxembourg, which is politically much more acceptable than the United States, because many countries in other parts of the world are suspicious of the United States or their intentions, or worried about its economic power. In Luxembourg, nobody's worried about the economic power of Luxembourg, or let alone the military power. So countries like China, Japan, again the UAE, have included bilateral agreements with Luxembourg to develop this international regime a little bit further, but on the basic understanding that unilateral licensing and that commercial exploitation is legal, as long as, again, it is in compliance with whatever international law will be developed in terms of non-pollution and non-interference and things like that, and as long as properly licensed. Belgium is interesting there, not only because it's the neighboring country of Luxembourg, but also because Belgium was, just like Brazil and Russia, originally rather skeptic. Now Russia has entered discussions with Luxembourg as well, although they haven't come to anything. And more recently, to my great surprise, Russia itself claimed the planet of Venus, not just the ownership over the resources, but it just says Venus is a Russian planet because we were the first to land something there, to crash something on its site. So, in other words, in Russia, there's also a change of opinion. It's not clear which way it will go, but things are moving there. And then finally, of course, there are the US Artemis Accords. We spoke about that briefly yesterday, which basically allow other countries to join the NASA-led initiative to bring the first woman on the moon, the next man, and to build settlements there. And if countries want to join that game, want to join NASA in those efforts, they have to basically agree that unilateral licensing of mining of the moon is allowable under international law. I want to leave it at that. I hope that it's clear that there is a lot of work for space lawyers, maybe not for space judges in the near future. That will be a little bit later, but certainly for space lawyers. And it continues to be a fascinating area. And this whole issue of space mining is just one example of it. Thank you for your kind attention. Over to you, Anja.
Thank you so much. That was quite incredible. And very informative, at least for me. I learned a lot. How about getting some questions from the audience? Do we have any? We had quite a lot of comments in between. Somebody mentioned that it's very interesting that Australia signed the Artemis Accords. And then further above, we had Daciana mentioning that asteroid mining corporations are also being established in the UK. But yeah, I mean, Saswati, do you have any questions? Juliana, Marina, Daciana, you can unmute yourself.
Yeah, I have a question. It's thank you so much, Professor, for giving this amazing lecture and this wonderful presentation. However, I have this one question. So when we start looking at space law, one of the basic questions that came to my mind was, where does the space law start from? Like, for example, we know it's easy to kind of say that, okay, fine, whatever we are standing on is the Earth, and whatever we see up is the sky and the space. But what is that measurement from the ground where the Earth ends and the space starts?
That's a great question. And it's one of the questions which have been discussed almost back since 1957, and we haven't come to a final solution. There are countries who say that, legally speaking, and I'm translating your question now into more international legal terms, a bit more specifically, that the sovereignty of states over their own territory extends up to a certain area. The airspace over countries is part of the sovereignty. So in your terms, that is part of the earth in a legal sense. No foreign aircraft can fly over another country through its airspace without the consent by that underlying country, and that consent may be subject to all sorts of conditions, and nobody can complain about that. That's part of the national sovereignty of every state. Because outer space is, of course, an area where national sovereignty does not apply, where you cannot say this part of outer space is mine, everybody has to keep out or can only enter on my conditions. The logical question which I sense behind yours is, where is the borderline between the two regimes? And the point here is that there are a number of countries who deny the need for such a borderline or find it too early for that. The countries which do think there should be a borderline put this at different altitudes. And the only thing I can say is that I see over the last decade or so a gradual convergence about the altitude of 100 kilometers. I don't want to go into too much detail for the sake of time, but if you want to quote a particular altitude, that is probably the best altitude you can quote for saying, well, here we leave the legal realm of air, of the earth, of the underlying state, and enter into the endless non-sovereign area of outer space.
Thank you so much, and thank you, Saswati, for this incredibly interesting question as well. I thank you, Frans, for joining us for the second time. It was amazing to hear you out and to see all these video clips and to hear who owns the moon and more about the extraction of the mineral resources. I hope we'll continue to have these discussions even after the summit. Thank you for being here for the last couple of days.